Thank you for waiting with us through the break. We've had a little bit of a reshuffling, so just to make sure everybody knows who everybody is. To my left, Judge Ayers is with us, and to my right, Judge Smith is with us. I'm Judge Eastman, and we look forward to the argument this afternoon. So, Madam Clerk, if you will call the case.
Jeffrey M. Ewers versus State of Tennessee.
Appellant, whenever you're ready to proceed.
Good afternoon, Your Honors. I would like to reserve 3 minutes for rebuttal, please. David Rabin and Ben Rabin, Davidson County Bar, representing Mr. Ewers. This case is a case of first impression. The issue that we're raising has never been considered, to my knowledge. There's one issue that I wish to argue. That is, was there a regulatory taking of my client's $500,000 condominium under the Fifth Amendment of the Constitution, Article 1, Section 25 of the Constitution of the State of Tennessee? That's the only issue I want to argue. It is dispositive. To my knowledge, no court has construed the taking provision, Claims Commission statute.
Counsel, there are different species, different types of takings. You mentioned regulatory takings here. In your brief, you reference physical invasions, you reference total deprivations of all economic benefit. Are those the two types of takings you're asserting? I know you're arguing regulatory takings here before us today, but are those the two types of takings you're asserting on appeal? Is there another type of taking that we should be considering?
Well, this is a constructive taking. There are I think 3 or 4 different species of takings that the Constitution contemplates, where the Supreme Court has categorized these takings in terms of what constitutes an unconstitutional taking. But I think rather than trying to pigeonhole what kind of taking it is, the cases focus on the harm to the homeowner, or in this case, whether there is a regulatory taking sufficient to functionally oust him from his home.
Well, I'd like to get a sense, though, because in thinking through the different rules, right, with these different species or types of taking, so to know what it is that we're supposed to consider. So then, and I want to make sure I'm not shortchanging you in terms of your argument with regard to what it is that you're advancing. So I wonder if we could take just a moment to sort of, if you could pin it down in terms of those pigeonholes and categories, which ones are before us. I noticed you said physical invasion. I noticed you said total deprivation of economic benefits. I'll ask you one that I wasn't certain about in terms of your brief. Are you arguing Penn Central as a separate type of distinct taking from those first 2 categories?
Yes.
Or you are, so it's a third type of taking that you are asserting?
And I think the Penn Central case is the Georgia case that I cite. Talks about the Lingle decision of the U.S. Supreme Court, which cites the Penn Central factors. So I think if you would refer to the Mann versus Georgia Department of Correction case that I cite, it is identical to our case, and the constitutional taking provisions that it cites are exactly what I'm talking about here. And so they just simply talk about the ousting a person from his home is sufficient regulatory taking to constitute a taking under the Constitution. So we rely upon the reasoning in the Mann case, and the constitutional arguments, the Penn Central factors, are precisely what is articulated in the Mann case, and it's exactly what I've got here.
How is this, and here, in terms of the factors, the economic loss here, right? The property actually sells for more than he originally purchased it for, right? And $10,000 or so more. Right. So is there really an economic loss as it viewed under the Penn Central analysis?
Because as Justice Holmes reminds us, it is not what the government gains, it's what the homeowner loses. As the Mann court case said, that in addition to the sale price of it, the purchaser can confront numerous expenses such as closing costs, attorney's fees, realtor commissions, etc. When he is ordered to move from point A to point B, he incurs costs, closing costs on both pieces of property. That's when we buy and sell houses. It's not just how much you sell it for versus how much you gain. That's not a measurement of loss. All the courts say that the closing cost, attorney's fees, are the costs of moving. Plus, this man had to find temporary housing while he was trying to find a place that fit within the sex offender registry. So he had 3 costs that were going on to him as opposed to somebody doing this. And it was a fire sale. He had no choice. So you don't measure just how much you gain or how much you lose. You associate the cost of moving is a loss. And that's $70,000 in this particular case.
There's a great deal of regulation that reduces, though, the value of property, where there can be losses that are far more significant than numbers we're talking about.
Correct.
Here. Your argument would seem to invite a finding of a regulatory taking with a significantly lower threshold than a lot of, candidly, the practical impact of a lot of regulation in reducing the value of property.
When you get $70,000, that's a significant loss. I don't think whether it's 100,000 or $1 million, 70,000 is not de minimis, if that's what the court is asking me.
Well, what about a case like Palazzolo? So in Palazzolo, you have a beachfront or you have an oceanfront development project. You have a 95% loss in valuation. The homeowner wants, or the property owner wants to develop a large sort of swath of property for beachfront cottages, houses,
Right.
and they can only build one. So instead of, it loses 95% of its value, and the U.S. Supreme Court in Palazzolo says no taking.
And I don't disagree with that particular situation, but this man is ejected from his home. That is this. All the courts say that is the most severe loss that of a taking when you get kicked out of your house. But let's go back to why this happened. I think that that's an important component. My client, the question the court needs to ask is this. I've said what the issue is. Here's the question. The loss here is $70,000. Should that fall on my client, or that should be the benefit, or should that be a cost to the state? One or the other. You either let this man suffer that's undisputed, or let the state pay for it. The court granted summary judgment finding out there was no taking, and that my client was at fault for establishing this residence to begin with. Respectfully, his fault or non-fault is irrelevant. As your honors know, in taking cases, negligence, contributory negligence of the homeowner is irrelevant. That's a tort concept, not a taking concept. But let's get down to the facts of the case. My client was on the sex offender registry. He was also on probation. One of his conditions was that he had to comply with the registry requirement. He couldn't live within 1,000 feet of prohibited places, schools, parks, that kind of thing. One of the places it can't live is an unlicensed daycare. There is no list in Tennessee of unlicensed daycares. You can find schools and everything else. There's no place that you can find. The state concedes that. So the state created a computer model. And so you can go on this, the state can go on the computer and find out exactly where all the exclusion zones are. You can put this courtroom in the computer, and there you can see whether it is or is not in an exclusion zone. It happens to be. In fact, from where I'm standing, there's no place downtown that's not an exclusion zone, except for the Capitol across the street. That's the only place downtown. It looks like thermonuclear devices have gone on because, and I've given you the URL, you can do that yourself. So, but that thing was not accessible to my client. The probation officers had it. He asked 4 times, am I okay to live here? Absolutely. Why? Because this unlicensed daycare center was not in the exclusion zone, was not in the computer, so he lives
And a lot
there.
of unlicensed daycare centers fall into that category, isn't that?
I'm sorry?
A lot of unlicensed daycare centers fall into that category.
They all do, because it's considered a child care facility. I use the word unlicensed daycare because that's the most common.
So it's kind of surprising that this has not come up before. If that's the sole method by which someone subject to the sex offender registry requirements determines whether he or she is in violation.
Right.
But there's nothing in the statute regarding the sex offender registration requirements prohibit the 1,000 feet. There's nothing that says how that is determined. It just says you cannot knowingly establish, which everybody concedes your client did not knowingly establish in this
Absolutely
case.
correct.
His problem is Part B of the statute that says you can't knowingly live within 1,000 feet of the residence.
That's correct.
So for however many months, more than a year, he had not knowingly established that residence, but once it became obvious that there was a daycare in the church there, then he could no longer live there because he would be knowingly then residing within 1,000 feet
Your
of
Honor,
a
I
child care
respectfully
facility.
suggest that the rule is not that way. The statute says it's illegal to knowingly establish a residence.
Right.
And then, if a residence comes along, there's a grandfather provision that says they build something next to you, you don't have to move. So merely that provision, Your Honor, is reading, is where you go upon the premises. So if he went onto a school, physically into the school, he would be violating that statute knowingly or not. That's what Part B deals with. Part A talks specifically about knowingly establishing a residence.
Right.
But if
I mean, Part B literally says no sex offender, blah, 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 shall knowingly reside within 1,000 feet of the property line.
Right.
On which, that's the part that deals with the victims.
Yes,
So,
if
okay.
you happen to be, if a
Gotcha.
victim lives there,
Okay.
which is not what we're dealing
Gotcha.
with here. So this is only a situation where you have to knowingly do that. And I think I'm running close out of my time. So what happened was they told him to move. And what I'm going to ask the court to do, the court's going to ask the state a lot of their own questions. Why did they tell him to move? He wasn't breaking any law. But the probation officer said, we're not going to tolerate sex offenders living within 1,000 feet of a school. I guess they have that right, but they have to pay for it because he didn't do so knowingly. And that's why we're saying the loss should fall on the government, because he didn't do this knowingly. And therefore, the question is not how he got there, but why he had to leave. And I invite the court to ask the state, why was he compelled to leave if he didn't knowingly reside there? And he didn't. And under those particular circumstances, you have a regulatory taking where he's ejected from his home. So it's not just the economic value to him, it's his place of residence and the loss that he has to physically move to comply with the orders of the probation court, or risk going to a different residence entirely, which has jails around it. So I'll come back and...
Thank you, counsel.
Thank you.
Good afternoon, Your Honors. May it please the court, my name is Pico Jenkins, and I represent the state of Tennessee. In this case, Mr. Ewers seeks to stretch the bounds of the Claims Commission's limited waiver of sovereign immunity by trying to fit the facts of this case into the enumerated causes of action. But he's seeking to fit square pegs in a round hole. Because first, the Claims Commission Act prohibits claims based on the negligent issuance of an approval. Second, he was not in the care, custody, or control of the state. And third, there was no unconstitutional taking of his property.
Counsel, let's talk about the takings issue.
I was going to.
With regard to the general, in terms of the takings issue, the Claims Commission here focused on his knowledge of he shoulda, coulda, woulda known that this unlicensed daycare was there. I'm curious, given the procedural posture, and this is a summary judgment motion, what are the facts that, taking a look at the evidence in the light most favorable, not to the state, but to Mr. Ewers, leads to the conclusion that he should have known that this unlicensed daycare was there? I mean, the state didn't know it was there.
Well, he has the responsibility to get his probation officer's approval, but that's separate than his statutory duty to ensure that he's complying. And there are other ways he could do that. He could consult public records, maybe call a leasing office, hire a third party to conduct.
Where is that in the facts, though, in terms of what statement of facts establishes? The closest I saw, and you may be able to point me to something that's closer, But the closest I saw is that the state asserted that he was aware that there was a church within 1,000 feet. And he, if I recall correctly, actually denied that he was aware of the church. And I may have that wrong. But what are the facts? I mean, that seems like a factual determination that he should have been aware of. And what's the fact in the undisputed statement of material facts that leads us to that conclusion? Because that seemed to be a hinge point for the claims commissioner here in thinking about this matter. And I'm just not quite sure how we got there at summary judgment.
And I'd say the issue of whether he knowingly established his residence actually goes beyond the bounds of this case. I think that's a statutory interpretation issue that's more properly decided in the criminal court context. But whether or not he was in compliance.
Well, isn't it relevant at least for character analysis in terms of the Penn Central issue? I mean, the character of the government's interest in the property certainly is affected by whether he's actually in violation of a statute or not in violation of a statute in terms of considering the government's interest in terms of restricting him. And it also seems to be the basis of the claims commissioner's decision. So I'm trying to figure out how the claims commissioner got there under the facts of the case in terms of how did the claims commissioner decide that he should have known? I mean, is there a fact that's closer than he was aware there was a church there?
I believe it's not so much a fact of what he did know as what he could have known with due diligence is what the claims commission was focusing on, and the fact that there were other ways to establish other than just the approval. But this case,
Opposing counsel in his brief says he can't walk into the church. And that he
hire a third party, he could consult public records, he could.
Is there any evidence are there any undisputed statements? Are there any statements in the undisputed statement of material fact that establish that he would have found it that way, that it is in fact in the public records, or that it is?
No, there's nothing in the statement of facts that says he definitely would have found it. It's more that there were other ways, and he chose to just rely on the approvals of his probation officers, and that's undisputed. And really, this case doesn't fall into the categories of takings that we've looked at. For regulatory type taking, with the Sex Offender Registry Act, it's really important. He was not deprived of all beneficial use of his property. And the Mann case, while also distinguishable, I'd say was wrongly decided.
So all deprivation of all economically beneficial and productive use is a per se category of taking, right, under the Lucas decision of the U.S. Supreme Court. But opposing counsel noted his argument that he's not just raising sort of a Lucas or a physical invasion issue, he's also raising a Penn Central argument, which is its own category of taking in terms of a broader consideration of regulatory takings that goes beyond. So how do you respond to opposing counsel's argument that we have a Penn Central taking? I take your point on Lucas. This is absolutely not a deprivation of all economically beneficial or productive use. I'm not sure how $500,000 selling a property could constitute that, but under Penn Central, how is it not a taking under Penn Central? Or how, as a matter of law, is it not a taking under Penn Central?
Well, if you look at, I'm sorry, 1 second, Your Honor.
And we have three considerations, right? We have economic loss, interference with the distinct investment-backed expectations, and character of the governmental interest. So 3 factors that we're weighing under a Penn Central taking. Opposing counsel says he's lost about $70,000 here, and he argues that that's enough to potentially constitute a taking. Maybe he's right, maybe he's wrong. I mean, why do you think he's wrong?
It did not necessarily interfere with his investment-backed expectations. While his expectation was to live in the house, his property interest in the land is already limited by the residency restrictions in place at the time he purchased the home. He knew about those residency restrictions. Those are built into his property expectations. Well, forced relocation may cause a negative economic impact, but that doesn't mean that it rises to the level of a taking. His fair market value is not diminished. He had the option of either selling and renting his property, and as we've established, he did actually sell it at a profit. And even though he couldn't reside within the restricted zone, many others could. This left open a broad market to sell or sublease his residence at full market value. Other courts that have considered the issue that Mann did have actually come to the opposite conclusion that Mann did, finding that it was a misapplication of the Penn factors.
Some of the courts have come to other conclusions, have looked at it in temporal terms, with the idea that the person was only limited for a certain number of years in terms of living in the property. Does the record tell us, with regard to Mr. Ewers, whether this is permanent that he couldn't live there? Is this temporary that he couldn't live there? And this is sort of an operation of the sex offender registry and conditions of his probation, I guess it is. Is he permanently barred from living there?
So long as the daycare that was pre-established was. And another difference with Mann is that we do have the grandfather exception here. If there was a new daycare established when he already resided there, that would not prevent him from living there. And the Mann court focused a lot on the fact that people could move to the offender. They could specifically move there with the intent of not letting them live there. Whereas that's not the case here. The property undisputedly did exist before that.
In terms of the character analysis, that third component, the Penn Central consideration in terms of whether a taking has occurred, to have him move, and the state, is he in violation of the statute? And hasn't the state conceded essentially in this case that what's the admission here? To the best of the state's knowledge, information, and belief, Mr. Ewers established a residence at a particular location based on his belief that he would not be in violation of the law in doing so. By conceding that, hasn't the state essentially conceded that he didn't knowingly?
I would say it's not a fact issue for the state to concede or not concede. It's a statutory interpretation issue of what knowingly established means, and that would have been more properly brought up with the DA in the criminal court context. Some courts, in looking at knowingly, have found that knowledge of the legal requirements.
But we're not looking at it in the context of a criminal prosecution here. We're looking at it in terms of the government, for the character prong of Penn Central analysis. You're looking at the government's interest. It strikes me the government's interest is different if the government is enforcing a law that he violated versus enforcing a law against him that he didn't actually violate. And that seems to affect the government's interest in terms of the actions it's taking.
Well, the government has an interest in protecting minors from sex offenders, and that's why those residency restrictions are in there in the first place. And the fact is that this residence did predate his establishment of his home. I mean, I think you could.
But hasn't the state conceded that he didn't know that he wasn't aware of that?
We don't have specific facts and evidence that he was subjectively aware.
But the undisputed statement of facts, the state conceded that he did not knowingly establish a residence in violation of the statute. Is that not correct?
Again, I think it would go beyond the scope of this case to interpret.
Well, and I think it's within the scope in terms of the third prong of Penn Central analysis. So, and I'm curious because when it comes to looking at the character of the governmental action here, it seems to have an impact. And maybe you can tell me where I'm wrong there, but if the government's if they're kicking him out for violation of a statute, they have a different character argument than if they're kicking him out and he didn't actually violate the statute. And that's...
Well, I think to say kicking him out is not quite accurate. His probation officers said that his residence was approved. They then revoked that approval once it was found out.
They told him he's going to jail if he doesn't move, right? I mean, and he has to comply as a condition of his parole with directives of TDOC. And TDOC's telling him you better move or you're going to jail.
TDOC did not directly tell him you're going to jail if you don't move. She recommended that he, to maintain his compliance with the law, that he should move.
Would he
Ultimately,
be subject to a revocation of his parole for violation?
Well, again, this comes down to the fact that he's really claiming that they negligently approved his residence, and that is prohibited under the Claims Commission Act, whether it's the issuance of an approval or revocation of an approval.
he can't bring a takings claim if, so.
You can bring a takings claim, but again, I don't believe this fits within the types of the types of takings that are available. I think that just because he might have trouble discovering all of the prohibited locations, it doesn't mean that there's necessarily a taking when this happens. And I think a lot of the physical occupation taking, he never physically occupied the property. His property rights remained intact, as shown by his ability to sell the property at market value. It was not a nuisance type taking, because it did not result in market value. And it did not deprive him of all economically beneficial use of his property.
When you're talking about a nuisance taking, though, I didn't understand opposing counsel to be asserting a nuisance taking. I do agree that the brief references a Lucas total economic deprivation taking, but it seems to me that a lot of this turns ultimately on a Penn Central taking in terms of whether that category is satisfied, because there's not, and doesn't appear to be a physical invasion of the property. It doesn't appear to be a total deprivation, all economically beneficial, productive use of the property. And maybe I'm wrong on those fronts, and maybe opposing counsel will set me right on that. But but I'm still struggling with Penn Central here in terms of that category of taking, in terms of whether.
But when it's a regulatory type taking, the government regulation has to be so onerous that it's tantamount to direct appropriation or ouster, and it applies to regulations that deprive the owner of all economically beneficial use of the property under Lingle v. Chevron.
I think we might be conflating Lucas takings with Penn Central. And Penn Central is essentially an outgrowth of the Mahone standard that provides a broad-based way of addressing regulatory takings and when they go too far, right? So Penn Central defines the concept of too far by the United States Supreme Court in terms of how a Fifth Amendment taking occurs. And so they've given us a 3-factor test for it.
I think you would run the risk of, I think the fact that they have that grandfather provision in, you would run the risk of people being willfully ignorant of when there were schools or something. That's why it's so important to distinguish the Mann case based on the fact that they did not have a move to the offender type exception. And
on that point, that's one of the places I tried to start in terms of our discussion is the claims commissioner says, and it's an interesting sort of thought with it, he should have known that what I'm trying to figure out is what's the fact that shows me, and this is off summary judgment, what's the fact that shows me he should have known? Maybe ultimately the facts bear out that he should have known, and maybe that's a way that it's not a taking. But I'm wondering, for summary judgment purposes, what's the fact I can look at and say, yep, that with taking a look at the evidence in light most favorable to him, he still should have known.
I believe his general knowledge of the area, his knowledge that there was a daycare, that there was a church, the fact that he only relied on his probation officer's approval, and they can't take on the burden of him complying with the law. It's really up to him to make sure that he's not living in one of these prohibited areas. The statute doesn't put that burden on the state. So the fact that he didn't do more is really the evidence of lack of due diligence.
Thank you, Jen.
Thank you.
Thank you, Your Honor. I want to be efficient with my time. First of all, the state is the state is the state. Whether it's the district attorney's office or the Department of Corrections, it's all the state. The state took this man's house. That's it. We don't have to worry about whether it's a criminal law or whatever. He was prescribed on probation, prohibited in probation from living in a prohibited zone, and he asked 4 times, am I okay? Now let's talk about what the state says. Number 28 said it's undisputed that he did not know he was in violation of law. Undisputed.
What about the should have known aspect here? The Claims Commission looked at this and said he should have known. And there's a church within the 1,000 feet. He was aware that there was a church within the 1,000 feet. He should have known that the daycare was there. Why is that wrong?
Because there is no such should have known. just because there's a church, it's not illegal to live near a church. It's a daycare. The church happened to be in the facts show there's no signage on it. We proved that. There's no signage on this church. There's churches everywhere. There's no should have known in the statute. You know means actual knowledge. It's not like he pitched a tent in a schoolyard, Your Honor. Also, let's look at this. 1,000 feet from his home constitutes 72 acres. It includes parks, schools, daycares, unlicensed daycares. There are about 6 or 7 prohibited places that are in there. When you say he's going to go to the public records, what public records? You don't have to go any further than as important as this is to the state. The state didn't know this unlicensed daycare was there themselves. They have probation officers coming to his home to see if he's complying with the law. He's under curfews. If they didn't know it, how the heck was he supposed to know this? So given the magnitude of all of this, if this was open and notorious place, I wouldn't be standing here. But a daycare and an unlicensed thing, and I think you only have 5 children, 3 days a week, that's absurd to suggest that that's even should have known doesn't even meet that. Statute doesn't say that. Lastly, Your Honor asked this question. How long is he going to be on this restriction? He got a 12-year sentence. The sex offender registry, as a matter of law, the 15 years that you can have to serve on the sex offender registry is 15 years after you're finished with probation and parole. He hasn't even finished his parole yet. He's still got a whole nother 15 years to go, even at minimum. So he hasn't even finished that. I think that answers Your Honor's question on that. On the arrest, undisputed fact number 92. Mr. Ewers had to leave his home in order to avoid being arrested. Undisputed by the state. That's in the record. So what other choice did this man have? He's either going to go to jail for violating his parole officer's direction or comply. That's it. The state said you out, they're going to pay for it. Thank you.
Thank you, counsel. Thank you both for your arguments. I believe that's our last case, so we are closed with the afternoon docket.